This courtroom appearance starts like many others: a judge, a defendant, routine questions, but within seconds, it becomes clear this is anything but ordinary. We're watching a defendant who doesn't just challenge the charges, he challenges the court's authority itself. From trademarked names to exclusive equity, from international permits to federal registrations. This case quickly turns into a clash between legal reality and sovereign citizen style arguments. The stakes here are serious. We're not talking about a minor citation. We're talking about multiple criminal cases, including operating while intoxicated as a repeat offender, license violations, fleeing and eluding, and questions about public safety. And yet, instead of focusing on the evidence, the defendant repeatedly refuses to acknowledge the charges at all. This intro matters because what you're about to see is a masterclass in how not to represent yourself in court, and how patience, procedure, and judicial authority collide with disruption. As you watch, ask yourself, where does legal confidence end, and where does legal misunderstanding begin?
Your Honor, Magoo is Easy Elastical Trust, registered in Jackson County, on case number 2522246.
Okay, is your name Daniel Magoo?
Your Honor, that is the name you seek, and it is copyrighted and trademarked.
Okay, very well. Ms. Magoo, are you represented by an attorney, or do you wish to be represented by an attorney on these matters?
I am not.
Do you wish to be?
No, not at this time.
Let me then do this. You have two cases before this court, one being the case ending, well, let me get the full case number 25F40523. In that case, sir, the complaint does allege that on March 27, 2004, you committed the offense of operating while intoxicated. Do you understand what you're charged with?
I do not.
You do not understand
There is
that?
no eyewitnesses or corroborating witnesses at all.
I'm not asking whether or not the proofs are there. Do you understand what you are charged with?
I do not.
Do you understand the notion of drunk driving?
I do not understand how I could be charged with something without a witness.
On your other cases when you represent yourself, so we'll just do it.
You're talking about the case that's in federal court right now,
You
Your
are
Honor?
before a complaint in that case for a charge of operating while intoxicated, third offense. Because it's a third offense, that is a felony. It is punishable by up to $500 to $5,000, up 1 to 5 years incarceration. The court can order probation, 30 days to 1 year in jail, or at least 48 hours must be conserved consecutive.
This is the first major red flag. When the defendant claims his name is copyrighted and trademarked, he's invoking a common pseudo-legal argument that has no standing in criminal court. Courts do not recognize trademarked identities as a shield against prosecution. If you are physically present and charged, the court has jurisdiction, full stop. Notice how the judge doesn't debate philosophy here. He acknowledges the statement briefly and moves on, because legally, it doesn't matter. The court is focused on whether the defendant understands the charge, not whether he agrees with it. This moment sets the tone for everything that follows. The defendant isn't engaging with the process, he's attempting to derail it. And when someone represents themselves while rejecting the court's framework, that creates a dangerous situation. Every refusal becomes evidence of non-cooperation. Viewer. Question: do you think the judge should push back harder on these claims, or is ignoring them the smarter move?
As I am here and as a trust, Your Honor, I am here in exclusive equity. Exclusive equity.
You count 2 on that complaint is the charge of operating while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs, and your vehicle could be subject to immobilization.
My license is canceled, not suspended or revoked. It is canceled through the state of Michigan.
Complaint
canceled.
Is the charge of escape from lawful custody. That is a misdemeanor punishable by up to 1 year, a $1,000 fine.
I was never arrested or read any Miranda rights accordingly.
Given that the defendant is talking in English, that he understands English, understands the nature of those charges and what he's charged against.
So malicious prosecution by Washington County prosecutor as usual.
Sir, there is great peril in representing yourself. You will be held to the same standards as anybody apply or for.
This is a matter under the Eastern District of Michigan Federal Court. Case number 2511226.
We're not represented by counsel. I would further indicate, sir, that at any point you're in these proceedings, if you wish to be represented by counsel, you can make that request to the court and counsel would be appointed.
Here's where things escalate fast. The judge clearly explains the OWI third offense felony, potential prison time, fines, probation, vehicle immobilization, and the defendant still says, "I do not understand." This isn't confusion. This is strategic refusal. Legally, understanding doesn't mean agreeing. It means recognizing what you are accused of. The court only needs to ensure due process, and that's exactly what the judge is doing by spelling out each consequence in detail. This is also where self-representation becomes extremely risky. By refusing to acknowledge the charges, the defendant forces the judge to create a record showing that the court did everything required to inform him. That record will matter later. Ask yourself, is this a legal defense? Or is it a tactic that ultimately strengthens the prosecution's position?
For a complaint that alleges that on or about July 3rd of 2025, count one is fleeing and eluding fourth degree.
Added on by the
Police
prosecutor's
officer.
office after the
Sir,
fact.
that is a felony, punishable by up
Malicious
to 2 years
prosecution.
incarceration and a $2,000 fine plus court costs, mandatory suspension by the Secretary of State.
My Secretary of
two
State, anything
is
is canceled. I have
operating
no contracts with the state of
Vehicle,
Michigan.
that is a misdemeanor.
This
Charged
is a matter of trust, Your Honor. This is a matter of trust.
punished
I am protected
by up to
under a
90
trust.
days in jail, a $100 fine plus court costs. Count three on that complaint alleges operating a motor vehicle without security. That is a misdemeanor, not punishable by not more than 1 year incarceration and not less than $200 nor $500 fine plus court costs. Count four is operating while license suspended, denied, and or revoked. That is a misdemeanor.
All of my registrations are
By
through
up
the
to
federal government.
days,
I have federal government
$500
registration.
plus
I do
court
not have
costs.
contracts with the
Vehicle could
state.
be subject to mobilization. Count five on that complaint alleges refusal to obey refusal to.
I have an international driver's
Police
permit.
officer. That is a misdemeanor punishable by up to 90 days, $100 fine plus court costs. I would indicate to the defendant the same admonishments regarding the perils in representing oneself that I
This is
stated.
one of the most important moments in the entire hearing. The judge explicitly warns the defendant about the great peril of representing himself. That's not dramatic language, it's a legal safeguard. Once that warning is given and acknowledged on the record, the defendant loses the ability to later claim he didn't understand the risks. Notice how calm and methodical the judge remains. He repeatedly offers counsel. He explains the defendant has been through this before. This isn't impatience, it's documentation. The court is protecting the integrity of the process. From here on out, every interruption, every argument about jurisdiction, every refusal to answer will fall squarely on the defendant's shoulders. This warning is the legal line in the sand. Viewer, question, if you were facing felony charges, would you ever risk going forward without an attorney?
Look it up.
No, you guys disconnected my access to any kind of law library or anything. You are an Article 6 judge under the Michigan Constitution. You have no authority to deprive me of my
We'll
rights.
see how much authority I have. I will assume that you wish
This is
to
a matter
proceed
of
without
trust.
counsel. I will assume you wish to proceed without counsel and that you will wish to continue to proceed.
Practicing law from the
until you
bench.
Inform the court otherwise. Ms. Lonnie.
Thank you, Your Honor. Is the court completed the arraignment for the record at this time?
Well, he had been arraigned. I was just admonishing him of the perils of representing himself and that it requires in part that I let him know what he is charged with. And I've read them kind of in fully, more so than I would have because he refuses to acknowledge those. So I am satisfied that he now knows all of the charges that are against him.
Thank you, Your Honor. The people would like to be heard on bond when appropriate.
All right. What do we want to set this for? Do you wish to have a preliminary examination, sir?
This is a matter of a federal matter now, Your Honor, under case number 2511226, under the Eastern District of Michigan, under the Honorable Mark A. Goldsmith and Magistrate Judge David R. Grand. There is no proceeding here, Your Honor.
There is no proceeding. Oh, there's a proceeding.
Well, malicious prosecution is what the proceeding is.
Okay, very good. Do you wish to have a preliminary examination?
There's no proceeding, Your Honor. This is a matter that should be stayed and
What is
dismissed.
This exchange is a textbook example of a misunderstood constitutional argument. The defendant demands to know whether the judge is Article 3 or Article 6, implying the court lacks authority. But state criminal courts operate under state constitutions, not federal Article 3 jurisdiction. The judge doesn't need to debate constitutional theory here because jurisdiction is already established by the venue, the charges, and the defendant's presence. Arguing otherwise doesn't pause the proceeding. It simply reinforces the perception that the defendant refuses to engage in reality. What's more telling is the judge's response. He assumes the defendant wishes to proceed without counsel and moves forward. That's power. not shouted, not asserted, but exercised through procedure. This moment shows that courts don't need to argue authority. Authority is demonstrated by action.
There's video evidence in addition to the paper discovery. I've got to make arrangements with Lieutenant Arnett to work on that. So it may take just a bit longer. I would potentially look at the 7th, maybe, if the court would have entertained that. And then I will wait to be heard on bond when the time is appropriate.
I will adjourn the probable cause August 7th, 2025, 9 a.m. As to bond.
Your Honor, I've been reviewing ex-jail and I wanted to double check if the defendant had been arraigned. It's not clear to me from a couple of different things, but it does appear that he has been set with a $10,000 bond in 25 F30979, as well as 25 F40523, each $10,000.
Yes.
Your Honor, I do think it's important that the court have some additional information, and I would like to ask the court to revisit the issue of bond. First and foremost, I think it's important the court know that the facts alleged in the newest case, the 25 F30979, it does include the fact that the Michigan State trooper who pulled the defendant over noted in his police report that the defendant had a license on his vehicle that indicated he was a diplomat and that he refused to identify himself. He refused for quite a bit of time. Additional units had to be brought.
This is the moment where everything converges. After hearing the arguments and reviewing the history, the judge concludes that the original bond was an abuse of discretion. The court finds the defendant to be both a risk to the public and a flight risk, and the bond is raised to $50,000 cash in each case. This ruling isn't emotional, it's procedural, grounded in the record, and focused on safety and compliance. Regardless of personal beliefs or alternative legal theories, the court operates on established law, and that law has consequences. This case is a powerful reminder. Courts don't respond to defiance with debate, they respond with orders. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more courtroom breakdowns.
That case out of?
That case is out of 14B, Your Honor, before Judge Washington.
A co-defendants with the federal case that you guys are both in, and this is a conflict of interest as both of you guys are defendants in my federal case.
Go ahead.
I also understand, Your Honor, that there is a municipal case out of Canton Township that was set for a jury trial in April of this year where the defendant failed to appear. And came up. He was in bench warrant status before Judge Slay, is my understanding, for refusing to come after the case here had been bound over, refusing to appear in person. I say all of that to say this. I do think that $10,000 is too low. And I also am going to request a SCRAM tether because this is an OWI 4th alleged, as well as a GPS tether, given his history of failure to appear and failure to comply with court regulations. Thank you, Your Honor.
Is the bench warrant before Judge Slay still out?
She has bond denied in her case now.
His bond's been denied in that?
Yes, that's correct, Your Honor.
Got it. Anything you'd like to say?
Anything to do with any contract?
Now the tone shifts because bond is no longer just about court appearances. The prosecutor lays out a troubling pattern: multiple pending cases, failure to appear, alleged alcohol issues, refusal to identify himself, and escalating behavior during traffic stops. This isn't punishment. Bond decisions are about risk to the public and risk of flight. When the prosecutor mentions a 4th OWI allegation and prior bench warrants, the court has to reassess whether prior bond amounts were sufficient. Notice how the defendant continues to argue contracts, permits, and registrations, none of which address the core concern: compliance. Courts don't deny bond because of beliefs. They do it because of behavior patterns. At this point, the case stops being abstract, and it becomes about community safety.